May I please, Your Lordship?
32 to.
Lordship.
Yes.
Lordship, this is an Lordship, this is an appeal against the order of conviction against the appellant that has been passed by the learned Session Judge Mazuli on 22nd of December 2023, whereby the appellant has been convicted under Section 380 of the Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment of 3 years, along with a fine of 10,000, and in default, 2 years simple imprisonment.
Heard, Mr. What is your name?
A. Khan.
A. Khan, learned counsel for the appellant. This appeal under section 374 within bracket 2 of the Code of Criminal Procedure, 1973, has been filed by the appellant Shri Marna Pegu, impugning the judgment and order dated 22/12/2023 passed by learned Sessions Judge Majuli in Sessions case number 29/2023, whereby the present appellant has been convicted under section 380 of the Indian Penal Code and has been sentenced to undergo simple imprisonment for 3 years and to pay a fine of rupees 10,000, and in default of payment of fine to undergo further simple imprisonment for 2 months. This appeal is admitted for hearing. Issue notice to the respondents and call for the record of Sessions case number 29/2023 from the Court of Learned Sessions Judge Majuli. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. The registry to take steps for requisitioning the trial court record list accordingly.
Lordship, there is an IA also, Lordship.
Two is that. One is disposal.
One disposal.
One was for combination of delay.
You have been
Well, a 3 years conviction, my lord. Perhaps he is in previous bill.
No, he is in the jail.
In the jail.
From the date of the order on sentence.
Judgment,
he is
my
in
lord.
jail.
will
From the date of judgment.
In
he is-
normally, my lord, 3 years conviction, it is previous bill. Health petitions we allowed in the previous bill.
That was inadvertently not filed there.
Or not filed, that's why they are in jail.
on what ground? Oh, yeah, only 3 years punishment. Now, what is your submission on this?
My lord, my submission is we have only record already called for, my lord. After receipt of answer, my lord, we consider their prayer, my lord. In otherwise, my lord.
What is
And
your submission?
Lordship, if I may submit, actually, Your Lordship, my submission is that this is a false case. The appellant, he has been just trapped in this case. If Your Lordship allows me to just take you through the petition, Your Lordship. Your Lordship, if Your Lordship may kindly come to page 72 of my petition, Your Lordship. This is a part of the judgment that was passed, Your Lordship.
389 clause 3 is applicable to which court? Trial court or appellate court? Trial court.
Thanks, Lord. It is for the trial court, Your Lordship.
So you have not prayed for,
My
because
lord,
it was
my
for
lord.
3 years only. You
Lordship.
could have got bail before the trial.
Before the
Lord,
trial.
inadvertently, that was not done, Your Lordship. So, Your Lordship, I am relying on
Three
51.
89 subsection 3, my lord. 389 subsection 3, my lord.
It is for the trial court.
My
Trial
lord,
court,
my
Your
lord.
Lordship.
If
Lordship,
they are satisfied, then they are in, yes.
Yes.
Lordship, I am pressing, since he is already in jail now. So I'm
Since
pressing,
when you are in jail?
since the date of the judgment, 22/12/2023.
Yes.
Lordship is an illiterate farmer, Your Lordship, and the only sole bread earner of the family.
No on merit?
Lordship,
On merit?
yes, Your Lordship. Lordship, if Your Lordship may kindly come to page 72 of the petition, Your Lordship, of the appeal. It is the part of the judgment, Your Lordship.
No.
Page 72. Para 2, if I may read, Your Lordship, of the judgment.
Yes.
Lordship, it states, on receipt of an Ezahar dated 3/3/2023 filed by the informant, Wahidul Islam, and the said case was duly registered, and the IO carried out the investigation. The IO visited the PO, drawn a rough sketch map, and recorded the statement of witnesses under 161 CRPC. The IO seized articles so and so,
What was the stolen property?
Mobile, my lord.
mobile
One
phones,
mobile handset.
My lord.
2 mobile handsets. Now, Your Lordship, as per the prosecution case, the case is that first and foremost, the SR was lost, then the investigation was done. After that, the seizure was done, and then the
What
arrest.
is 413? Section 413.
That is a habitual offender, Your Lordship.
It is triable by Sessions Court.
My lord, my
Lordship.
lord.
Why this case was tried by Sessions Court?
Because, Your Lordship, the 380,
380 is triable by Sessions Court.
no. 387 is
So why this trial took place in before
413.
session? 380 is not triable by Sessions Court.
413. Yes, Your Lordship, 413 is 10 years, Your Lordship.
By which court it is triable?
Sessions Court, Your Lordship.
Sessions Court.
See,
413.
My lord.
So because of 413, this case was tried
Tried by the
Mine.
Sessions Court.
Session, but
And I was acquitted under for
413.
303.
You were convicted under 380. only.
380.
Okay.
Your Lordship, my submission is that the prosecution case is that first the SR was lodged, then the investigation was done, after that seizure was done and the arrest. And the investigating officer in her deposition, she stated the same thing. That first the SR was done, then investigation, after that seizure and arrest. But Your Lordship, if we take the statement of the informant who had lodged the SR, that is at page number 50, Your Lordship. Your Lordship may kindly take page 50.
Yes.
I may read, Your Lordship.
Yes.
I am the informant in this case. I know the accused, but I do not know his name. My mobile phone was stolen by someone while I was sleeping in our camp. Our contractor has informed me that a mobile phone is recovered and lying in PS. Accordingly, on their instance, I filed an SR. So the informant says that someone informed him that a mobile has been seized by the police. It is the police station. After that, he went and gave the FIR. So the prosecution
How it
cases,
helps you?
prosecution cases, first SR was lost, then investigation was done.
Okay.
But here it implies that beforehand something was there and he just went and gave it in SR. And based on that, the appellant was arrested.
Okay. How it affects the merit?
Lordship.
How it affects the merit of the case?
No,
That-
Lordship. The thing is that what was the sequence of events? What was the chain of events? Whether SR was lost first, whether the mobile phone was stolen first, then SR, then
So-
investigation.
So is it your submission that whatever has been stated in the Azhar is not true.
Not true, Your Lordship. It is not true. Even the PW1, if we take the statement of PW1, Your Lordship,
No, for this 389 purpose, I just want your crux of your submission.
the crux of my submission
What is on merit? What is your case?
on merit, Your Lordship, nothing was recovered from me.
Okay.
Even the Caesar list, the Caesar witness, when the
Okay,
Caesar,
no recovery was made by.
no recover was made from me. It is just that I was trapped. I'm an illiterate person. And so I was trapped in this case. Even Your Lordship, the Caesar witness on basis of whose evidence he is coming.
From
this-
where the mobile was recovered? From whom the mobile was recovered?
As per the Caesar list, the mobile was recovered from my possession.
Your possession,
But Your Lordship,
before lodging of the FIR.
that is
No.
not sure, Your Lordship. From the prosecution case, that is not.
But it was from your possession.
Position.
It is said that it is from my possession, but it's not true, Your Lordship. And Your Lordship,
Okay, heard. Mr. Firoz Khan, F. Khan.
F. Khan, I am appearing on behalf of F. Khan.
What is your name?
A. Khan.
Heard Mr. A. Khan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant, Shri Marna Pegu, praying for suspension of the sentence which was imposed on him by the judgment and order dated 22/12/2023, passed by learned Sessions Judge Majuli in Sessions Case number 29/2023, whereby the appellant was convicted under section 380 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 10,000 with default stipulation. The said order, judgment and order has been impugned by the applicant in the connected appeal, that is criminal appeal number 81/2024. Stop. Learned counsel for the petitioner has submitted that the learned counsel for the applicant has submitted that the applicant has a good case to pursue in the connected appeal, as he has been trapped in the in this case, and the in this case, stop. It is submitted by learned counsel for the applicant that in this case, the stolen property are 2 mobile handsets which were seized by police even before lodging of the FIR. However, the testimony of PW1 does not corresponds to the sequence of event which appears from the materials on record. It is also submitted that there is a fair chance that the appellant may get a verdict of acquittal in the appeal. And as the sentence imposed on the present appellant is for a limited period of only 3 years, if he is not allowed to go on bail, if the said sentence is not suspended during the pendency of the connected appeal and the appellant is not allowed to go on bail, then in event of ultimately getting a order of acquittal in the pending criminal appeal, he would be greatly prejudiced. Stop. Considering the submissions made by learned counsel, also counsel for the appellant, also considering the fact that the appellant has been convicted for a short period of only 3 years. The execution of the operation of the impugned judgment is hereby suspended during the pendency of the connected criminal appeal, that is criminal appeal number 81/2024, and the appellant is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Sessions Judge
Majuli.
Majuli, with following condition that he shall surrender before the learned Session Judge Majuli if it is required after culmination of the pending appeal. And he shall not indulge in any offense similar to that for which he has been convicted in the instant case by the impugned judgment. With above observation, this interlocutory application is disposed of.
Obliged, your lordship. Obliged, your lordship.